All right. I don't see Commissioner Baker yet. There she is. Good morning.
Good morning.
All right, we'll go ahead and get started then. It's May 11th, 2021, and this is the meeting of the Fair Political Practices Commission Law and Policy Committee. Ms. Linker, would you please call the roll?
Commissioner Baker?
Here.
Chair Matich?
Here. Hang on, we have a minor technical issue.
Got a little bit of an echo there for a minute.
Right. It was a bigger echo here, actually.
Yeah, especially, I have a booming voice to begin with, so.
All right. So moving to item number 1, public comment for items not on today's agenda. Do we have any public comment for anything not on today's agenda? Hearing and seeing none, we'll proceed to item number 2. It's approval of the April 13th, 2021 committee minutes. Commissioner Baker, do you have any edits, comments for the minutes?
I don't. I've moved to approve.
All right, I'll second. Ms. Linker?
Commissioner Baker?
Aye.
Chair Matich?
Aye.
The motion passes.
Thank you. Moving to item number 3, our legislative update, and we are joined this morning by our Leg Counsel, Lindsay Nakano. Good morning, Ms. Nakano.
Good morning. Okay, I've got updates today on a couple priority bills, including relating to costs, and on a couple other commission-related bills. The 2 commission-sponsored bills relating to LLC disclosure, AB 236 and SB 686, passed in their respective policy committees last month. AB 236 passed out of the Assembly Appropriations Committee, and SB 686 is in suspense. Or on suspense in appropriations. Commission staff have determined that the FPPC will need 1 additional special investigator position for these bills. Additionally, we learned in the SB 686 Appropriations Committee analysis that the Secretary of State is also putting costs on the bills in the amount of $561,000 in first-year costs and $121,000 annually thereafter. I reached out to SOS to get the cost breakdown, and the bulk of the first-time costs is for project development, including for software-related changes, and the annual costs are for 1 additional position to manage increased filing activity. And I'm meeting with SOS staff this week to go over those costs in more detail. On these 2 bills, I've also reached out to Cal Chamber, who had submitted letters of opposition detailing their concerns. I shared with them that members of the Commission have expressed willingness to consider amendments to both the threshold amount of the cumulative capital contributions and the look-back period with regard to which members would be included in the new disclosure. Cal Chamber indicated that they are reviewing these potential amendments, but I haven't gotten their thoughts on those yet. The remaining 3 priority bills for the Commission, AB 378, 1367, and 1590, are moving along without opposition, and I've indicated their current location in the legislation report. I also have a couple updates on other commission-related bills. For SB 459, relating to lobbying reports and issue advertisements, Commission staff has determined that the bill will require 3 new positions, 1 in the legal division and 2 in the enforcement division. The legal position is for the projected increase to advice requests, and the enforcement positions are for the increase to referrals due to increased filing and reporting requirements, and for the new issue lobbying advertisement requirements. For SB 752, relating to disclosure requirements on online political ads, Commission staff has determined the bill will require 1 new position in enforcement, and this estimate is based on the assumption that the existing limited term positions from the original Disclose Act will be made permanent this coming fiscal year. If they're not, neither enforcement nor legal would have the ability to absorb any additional work and would need additional positions. Staff has also provided technical feedback on SB 752 and also a request to include an additional amendment that was discussed at the last Law and Policy meeting, relating to disclosure on online ads, where currently a committee is only required, in some cases, to include the ad disclosure on their profile or landing page or on a similar location instead of on each individual ad paid for. Both Mr. Lang from the California Clean Money Campaign and the Author's Office are reviewing that feedback. One of the major elements of the feedback relates to the work of the Commission's Digital Transparency Task Force. Based on discussions that the task force has had, including at their meeting last month, I think it's very likely that the task force will recommend to the legislature in their final report that a study be conducted about what makes for effective disclosure on digital political advertisements. And it would be the hope of the task force, I think, and the Commission generally, that changes to the disclosure requirements, especially some of the very specific and detailed changes, would be put on hold until we have the results of the study and good data on what would be effective when it comes to disclosures on digital political ads. So I'm awaiting their response to our feedback, and I will keep the committee and the Commission updated on that. And with that, I'm happy to take any questions.
Great. Thank you, Ms. Nakano. Commissioner Baker, questions for Ms. Nakano?
Thank you. Yes, and a couple minor questions and also comments. I did go back and watch some of the elections committee. Of course, during the elections deadline or bill deadlines, it's a little bit crazy, and I compliment you on the representation of the Commission and all the testimony and making it through that. I know there were sparks flying on other bills, and it was nice to see they weren't related to ours. In the last meeting, either the Commission meeting or possibly the committee meeting, I think it was the Commission, we looked at Mr. Lowe's bill that used to have one bank account rules in it. That was taken out, and when we last chatted about it as a Commission, we were going to look at what the concerns were and if it might be put back in. I'm sure if you had any other updates at this point, you might have them in your memo or report. Did we get a better sense of what the concerns were about the one bank account element of his bill?
Yes, I haven't prepared that actually today, but we are looking into how to add that back in a way that addresses their concerns and would allow that to go through in the bill. And I can provide an update on that moving forward. That's fine. It's as I say, it's one particular little nitpick issue that I had about the bill, as I was hoping it would have we'd be able to get that back in there. So thank you. That it sounds like it's still being worked on. So we're efforts to do that. The other was with respect to AB 236 and SB 686. First of all, I want to thank you for, again, reaching out to the chamber to let them know what we as a commission sort of indicated. I would say that's going above and beyond. I certainly hope there will be some very constructive proposals made to us. As I've mentioned, I think the threshold for triggering reporting is too high, and the look back period, I think, is one that could be adjusted. I'm hoping some good proposals will be put on the table. It's much better to have them when the bill's originally being made than to try to go back and change things. And I just want to thank you for taking the extra effort to reach out to them again. I don't know that we had even asked that you take that extra step, and I think that was an extra step, so I appreciate it. And with that, that's my questions and comments.
Ms. Nakano, sticking with 236 and 686, what's the timeline for in which we would have to review amendments in a timely fashion and for the commission to weigh in on those? Like, where are we at the process, and how much longer are we going to wait for these amendments, if any?
Hopefully soon. I don't know exactly what the deadline is for that. I can talk to the committee consultants and see when we need to get those in. But that's something I can update on.
That'd be helpful if they have internal deadlines. I think certainly the committee and the commission would be well served to know what those are. All right, Commissioner Baker, anything further for Ms. Nakano and our ledge report?
No, thank you. No, thank you.
All right, thank you, Ms. Nakano. Great job as always.
Thank you.
All right, we'll now move to item number 4, and this is a continuing discussion for the committee on behested payments. Sort of to tee this up, staff has, over the last several months, presented some information to the committee and to the commission on, ranging from basics of how behested payments work, what they are, how they're reported and some ways that staff has identified that we may be able to refine our approach regulatorily through behested payments. There have also been a number of areas in which staff, I think, has been very clear that we don't have regulatory authority. It would require legislation with respect to some of those issues. So we have Senior Counsel Karen Harrison here today with us to review some of the things that we've looked at in the past, and staff has some new ideas which haven't previously been presented to the committee or requested by the committee, so we'll hear those today as well. So, Ms. Harrison.
Good morning. Good morning, Chair and Commissioner Baker. Karen Harrison, Senior Commission Counsel. Following up on prior information presented to the Law and Policy Committee, staff has identified 4 areas that the Commission may wish to focus on for possible additional, excuse me, I'm sorry, my video apparently did not start. There we go. To continue, possible additional regulatory action to implement and administer the behested payments definitions and reporting laws. And these are the laws found in Section 82004.5 that defines behested payment, Section 82041.3, made at the behest of definition, and Section 84224, behested payment disclosure requirements. This is in the context of payments made at the behest of an elected official and made principally for a charitable, legislative, or governmental purpose that we're speaking today. Behested payments covers other areas in the Act, but that's our focus here. And just to refresh, a payment is considered behested and reportable when it's not made for election-related activity. That meets the definition of a contribution. When the payment is not made principally for personal purposes, which is what we understand to be a gift, and the payment is made principally for legislative, governmental, or charitable purposes, and it's made at the behest of the elected official. This is defined as under the control, at the direction of, cooperation, consultation, coordination, in concert with, at the request or suggestion of, or the express prior consent of the elected official. And then under Section 84224, an elected official reports behested payments when they total 5,000 or more from a single source in a single year. And under that reporting requirement, they provide the name and address information of the donor, payor, and the recipient, the payee, and a brief description of the purpose of the event or the event. The 4 areas that we've identified for consideration, just to start off with, there is in the language in Section 82004.5, C4 and C5, they characterize payments made at the behest as a behested payment if they're made principally for charitable, legislative, or governmental purposes. These are payments then that may have other purposes or results, and those other components may be regulated or reportable under the Act, such as a resulting gift or resulting income. To administer and implement this section, the Commission members may wish to consider directing staff to draft regulatory language that provides guidance on how to evaluate and report these ancillary or secondary purposes or results. It may be helpful to have, for example, simple language stating that the portion of the behested payment that confers a personal benefit on the elected official, that portion is subject to the Act's requirements, reportings, and limitations for income or gifts. In those situations, the full behested payment amount would be reportable under Section 84224. So this is reaching a small number of incidences where this might occur. And then there's complicated situations that you usually see in an advice letter context, where there needs to be a determination of that portion that may result in income or gift, whether or not the donor payee would be considered a source of income or source of the gift to the official. And these come up in the conflict of interest context, and you'll see them in advice letters. So the payment is flowing to the third party, to, let's say, a nonprofit organization, but somehow there is some sort of income or gift benefit that's flowing back to the official. So looking at past advice letters, staff has identified potential factors that relate to control over the payment, employment with the recipient organization by the elected official or their family member, immediate family member, personal use, exclusive use of that portion of the payment, and if there's been any direction on the part of the payor, the donor. So these items are covered in the memo items 1 through 4, and there's an item 5 that is not usually discussed in the advice letter context, but it's language that the commission may wish to consider, and that's from Regulation 18943, and that deals with a gift to an official through a family member. In that instance, even though the gift flows to someone besides the elected official, it's considered a gift to the official under particular circumstances. And that's where there's no evidence that would otherwise account for the relationship of the gift giving. And there's a proceeding that the elected official may be a decision maker in. And these are particular proceedings that are of concern there: contract, license, permit, or entitlement decision pending. And then item number 6, this also is reflected in advice letters, and this relates to tangible items. And there are requirements in Regulation 18944 for payments made to an agency for use by agency officials that the commission may wish to explore some of that language to address particularly tangible items where there's some use or personal benefit to the elected official. I'd like to stop here and ask if you would like me to continue on through the other 3 areas, or if we want to stop and have some discussion. It's as you wish.
I think it'd be helpful to take them sort of point by point. So why don't we pause for a second? I know I have a couple questions, but Commissioner Baker, I wanted to ask you if you had any questions before I pop in.
I don't have questions, so I defer to you.
All right. Ms. Harrison, can you, just taking a step back, historically, when the legislature enacted the behested payment statute, prior to that time, my understanding is there were sort of two buckets that something could be placed in. It's either a contribution or it would be a gift. The legislature decided to create what is essentially a third bucket now, so behested payment. So a payment, either it's going to be a contribution, it's going to be a behested payment, or it might be considered a gift. Is that consistent with your understanding of the legislative history?
Yes, prior to the behested payment rule coming into effect, things fell into gift, income, or contribution categories when a payment involved an elected official.
Right. So the legislature decided to, and well, let me ask you, prior to the behested payment statute, if a public official asked a donor to contribute to a nonprofit, how would that have been treated? Would that be considered a contribution? Would it income? What would it have been?
I think that's an interesting question. I wasn't with the commission at that time period, so I can only address advice letters that I've seen in the past. And so the analysis would have been under the definition of gift and definition of income and definition of contribution. So it would be fact specific on the circumstances.
All right. Looking at the behested payment statute, is there, I guess my question for you is, what in the statutory language supports a regulatory approach, as you're suggesting here, where we would essentially pick apart a behested payment, something that's categorized or reported as behested payment, and say that in fact it's actually, a behested payment, part of it, and the other part's going to be a gift? Where's the statutory authority for that type of an approach?
If I could clarify, the approach that's been taken in advice letters that I've seen is that the full amount of the payment would be a behested payment. And then the portion that results in, let's say, a meal that the member or the elected official may enjoy that's a part of the behested payment would be reported as a gift to the officials separately. And so that's a consideration that's appeared in past advice letters. If that's something the commission wants to give us additional direction on, that's something we're open to hearing.
Well, let me keep going on that point, because I think what I'm understanding from what you said, and my understanding is we already have gift rules that make that clear. That if I behest a if I'm a public official and I go out and ask folks to contribute to a charity, and then I attend an event at a charity and I get a free dinner, that's just an ordinary application of the gift rules, isn't it?
Correct.
Okay. So I guess what I'm just trying to understand what the problem is. If we already have rules that cover this, what is it that we're trying to solve in this first idea that staff has brought to us?
I think the idea would just be clarification. And again, it's an option for the commission to consider.
Have we received advice requests, or are we having problems with enforcement on this particular issue?
Not that I'm aware, no.
Have we addressed this in our training materials or our manuals in some other way?
I believe that in our materials on the gift limit, that this does come up. I think that this idea came about with the notion that there can sometimes be an all or nothing type of view, that it's either all a behested payment or it isn't. And this just recognizes what you were saying, that if you receive a meal as a part of the behested payment, don't forget that that comes with some reporting requirements too. This might not be necessary. It's just a suggestion.
All right. Commissioner Baker, I've been talking for a while. Do you have a question?
Thank you. I think you're getting to it, that what are the indications that, I mean, there are other issues regarding behested payments, and we're going to get to them for sure. But the issue of how much is reported as a gift and whether it's reported as a gift, what are the indications that we have, either in complaints or requests, that there is a lack of clarity in this? Maybe I'm asking the same question that Chair Manich has, but what have been the primary indications that there is need for more clarification?
I think that this comes in the more complicated scenarios where you have, say, an elected official who's also employed by the nonprofit that is receiving the behested payment. And that's where it gets a little more complicated. And so that's what this item 1 is trying to address. And these are things that some people refer to a true behested payment. And that's where the payment is directed and it flows from the donor to the donee. And the elected official is just sort of sending it on its way. But when the elected official is also connected somehow to that recipient, that's when it gets more complicated. And those are the advice letters where we're trying to look at factors to see, is there a gift component? Is there a personal benefit? Then how is it treated? Is it principally for a charitable purpose? Who has control over it? For example, if the money were to somehow go into the personal finances of that elected official, get commingled with a family foundation, that would be an issue. So this is drawing on past advice letters. And
Okay.
the complicated situation when there's that additional factor of direction, control, or employment.
Okay. I mean, I certainly think I might have been seeing this a little bit overly focused on the gift component, maybe even the example that was given where an elected official suggests that a charity receive contributions and then attends the event and gets a dinner out of it. I was focused too much on that. I think you're absolutely right that the scenarios where an elected official receives some form of income or is tied or connected to that nonprofit is of great concern. And that, I think, leads me to my next question. And that is, if you could recap a little bit, what we can change as a commission and what would need to be, what the legislature has to change. And I respect that for the last year, commission staff, your team has gone through quite a bit of briefing and analysis of this last May, last August, last September. And it was very constructive. But if we had to summarize what we are able to do in addressing that area where an elected official has a connection with the nonprofit, maybe income or spouse has income, versus what we'd need to have the legislature do. we have limited jurisdiction. We're only empowered to do so much. Can you, and this might be a question for Mr. Bainbridge, but what are we allowed to fix in this area without going to the legislature?
Well, just to address your prior question real quick, the original impetus, and since you weren't on the commission at the time, and I'm sure you weren't watching every single one of our meetings back then, the original
well, I have
impetus,
gone back
think,
and watched the ones in the last year on
okay.
behested payments. They're very substantive meetings, but thank you. I appreciate the recap.
Yeah, this originally came from the commission meeting where there was a discussion amongst the commissioners, motivated largely by news articles they had seen about behested payments and a perception that there was personal benefits going on disguised as behested payments. So this section, that was where we started to address it. It was less something we had seen internally and more driven by what had been in the newspaper and what the commission at that time had asked us to look into what issues there were and what potential things we could do through regulation to address it. So this is kind of what we had come up with as a possibility on the regulatory end. In terms, obviously, to roll into your next question, the statutory responses are much broader in what could be done. You can change the definition of behested payment. You could do basically anything you wanted to do. But under existing law, we're pretty limited in what we can do in terms of behested payments because the definition is what it is in the statute, and we can't do much more with that.
And it may come to our work later this year of what legislation we might recommend for the next session on this area or working with the legislature on it. Okay, so good. It looks like most of the areas then where we are currently empowered to address the concerns about a legislator being connected directly to a nonprofit are in maybe how much we are asking disclosure to be enhanced or definitions. That's about it. I don't want to overly narrow us on that, but.
No, I think that's a pretty fair analysis.
Thank you.
So following up on that, because I think Commissioner Baker's correct and Mr. Bainbridge is correct in his recollection, sort of the impetus a while back for the commission was looking at what options we had where there was this personal benefit by a public official by virtue of something that they have behested. And at some point, I don't recall which meeting it was, I think it became relatively clear, though, that part of the solution here is defining more clearly the boundary between something that is a gift, properly categorized and placed in the bucket as a gift, and something that is a true behested payment. And my question for Ms. Harrison is, under our current gift rules, if I'm a public official and I'm employed by a nonprofit and I behest a payment to that nonprofit and then I make personal use of some portion of that, isn't that already covered in our existing gift rules?
Yes, it is.
All right. And if you take that fact pattern, instead of me being employed, it's my spouse. Isn't that also today currently covered under our gift rules?
Yes, it is.
All right. So to my mind, we have rules in place to address the problem sort of writ large that we have identified previously at the committee. Commissioner Baker's identified, certainly it's been in the news media. And to my mind, I think when I look at the proposals that staff has presented to us, I think proposal number 2, increasing the specificity of the information that's reported, is something that it seems like we have regulatory authority to do, at least at some level, and might assist us in applying our existing rules that are already in place that define what a gift is. And so this might help having some additional information. And so I think, to my mind, after having sat here through all these meetings, this is really the fertile ground for us. We already have factors that are articulated in advice letters. We have gift rules. If we believe that this is a widespread problem, asking for additional information. It may help us track it so that we can get a better handle on how big of a problem this really even is. I mean, I think it strikes people as it's egregious when it happens, but one thing that I'm interested in is I'd like to know how often this really happens. Is this one out of every, 1,000 behested payments involves a public official that may have some relationship to a nonprofit? Is it more frequent? Is it less frequent? I think that's the kind of information we'd want to track before we start changing the substantive regulations too much in this area. I don't know what your thought on that is, Commissioner Baker.
Well, thank you. So let that sink in. I agree, but I think certainly when we have data and information and we can track it and ground it, that's helpful. I would always find that helpful. But you can also have situations where it's only one nonprofit and it's one very powerful person. And it might be one out of many behest payments. And we've seen the expansion of behest payments just in the last year. I think I read somewhere our own website indicates the expansion of it. I've read that 10 years ago, 2011, it was about $100,000 in behest payments. As of 2019, it was almost $3 million. That doesn't include the last year, which has been a year of a lot of reporting on our own website. So the fact that it's expanding already rapidly, when I say it, the use of behest payments, the reporting of behest payments, to me raises a concern. Plus, who gets them? If it's just a few people, if we have data that this is really something that's only happening in a few instances, that may be enough to undermine the impression of integrity or fairness in government. If it's, I'm trying not to call out any particular legislator, but let's say it's a person who's in charge of the whole assembly, maybe the speaker or a majority leader or a chair or of a committee, and they're connected with a nonprofit. That might only be one person and one nonprofit, but it could have disproportionate impact on the impression people have. So I would just caution us that it'd be very helpful to have the tracking, but if it looks like something's in small amounts or there's only a few nonprofits where it happens, but the influence that may be questioned or the appearance of influence is dependent on who it is. And so I just am mindful of that. It's a bit of a ramble, but I like data. I just know that I think it's going to be important to see where it's at. And I think the broader concern is that there is such an increase in behest payment reporting, and they're taking different characteristics. One is if a legislator has some very direct connection with the nonprofit, and if the dollar amounts aren't much, but it's basically another way they can control and influence. It's also a way for nonprofits to curry favor before something's being voted on. And that would be something that I'm not sure we could really get just by tracking the information. So it's a complicated issue. I think my ramble here is probably stating that, but that would be my concern, is to say there isn't more to do. We just want to get some data on it. And maybe that's not what you're saying, Mr. Chair.
No, what I'm suggesting is that we have heard from our staff, this isn't the first time, that we have gift rules that, if they're applied and enforced, address some of the most egregious situations that have been reported on. So I think there's that piece of it. So before we rewrite the behested payment rules, maybe we ought to enforce our gift rules, because if that is sufficient, then we don't need to change these rules. Secondly, I think there's a heavy dose of, and in my opinion at least, folks are questioning whether behested payments are something that we should have or not have. I think that is a perfectly fine policy debate for somebody to have. It's just not a debate that we have here at the Commission. I mean, that is, we can certainly weigh in on a legislative proposal, but the law of the land today is that behested payments are permitted. There's no prohibition against a behested payment in a lot of the circumstances that we talk about today. We're trying to get our arms around this. And so that's why I think if we have gift rules that can address the egregious situations, let's start enforcing those then. Let's track some additional data so that we can get our arms around exactly how broad of an issue this really is with respect to nonprofits that have relationships with public officials. There is something for us to do here. I just don't think rewriting the behested payment rules and assuming that because there may be a couple bad actors that everyone is acting inappropriately is the right approach for us.
I can absolutely agree with you there. I guess I haven't had a sense yet that we are not enforcing the gift rules. And maybe it's calling attention to the fact that I'm getting the sense we are. I think we've gone to the underlying questions of where has there been lack of clarity? And what I'm hearing so far is there hasn't been much indication that there's been a lack of clarity. It's that the information is already required. And I do think there'll be there may be some areas where we're going to want to weigh in. We can decide if we sponsor legislation on it or not. I'm mindful of the presentation that was given at an earlier meeting before I was on the committee by a San Francisco ethics leader that said, some things disclosure is the solution, but there was actually some discouragement in that report that we not just rely on disclosure, that there may need to be more changes in the conflict of interest rules themselves. Do we have a sense that the gift rules are not being enforced and that the data is not there? I think the read I've gotten is that they have been, and the information is out there. I'm not saying we don't undertake some of these recommendations, but I'm not getting the read that it's not there.
Yeah. Or Mr. Bainbridge, one of you. Oh, actually, there we are. Chief Enforcement Brereton, good morning.
Good morning. I wasn't able to speak this morning, but I am not aware off the top of my head of any issues that we've had with reporting. With enforcing the gift limit rules or reporting of gifts. I can check with my staff and see if we've got anything coming up, but I haven't been flagged on any issues.
Thank you. Okay.
All right. Thank you. All right. Commissioner Baker, did you have anything else on point number 1 in Ms. Harrison's memo before we let her move on to point number 2?
No, thank you. Very helpful.
Thank you. All right, Ms. Harrison, you're up. Point number 2.
So I think we're ready to talk about data. And so point number 2 has to do with collecting possible additional information. Currently under section 84224 behested payment disclosure, when a report must be filed, it's to contain the payer's name and address, dates and amounts of the payments, the payee's name and address, and a brief description of the payment's specific purpose or the event. The committee may wish to consider directing staff to propose regulation language requiring additional information to better inform the public and to provide a disclosure perhaps of a relationship, if any is involved, a brief description of that relationship. So there's some options that staff has come up with for the commission's consideration. And one is just tightening up when the charitable organization is identified, what type of charitable organization they are, what sort of 501c status they have, and a federal tax ID number. And the idea behind this, again, is data collection. It's very easy for the public to go on the IRS website if they have the tax ID number. It enables them to pull up a lot of data about that particular organization. If you know the 501c status, you know whether it's a C3, if it's a charitable organization. There's other C statuses that might be of interest to the public. So that was the idea on the first option for consideration. And again, going to the idea of these known relationships, perhaps requiring a brief description of any known relationship of the elected official or their immediate family member, executive campaign staff, office holder staff, to the nonprofit organization. And this could include things like any role as a board member or executive officer or salaried employment. And again, that's trying to reach some of the factors of influence that have been articulated in other situations and that you were just discussing previously, some of the language would be a nod to factors that we've looked to in determining whether a nonprofit is a controlled committee of a candidate, for example. It reaches to those campaign staff, office holder staff relationships, but that would be for the commission's consideration. And then a brief description of a proceeding where the elected official knows or has reason to know that the donor payee is a participant. And we would recommend limiting that to proceedings involving a contract, license, permit, or other form of entitlement, and then setting a particular time frame. And the 12 months, it was a time frame bracketed in the memo as a suggested time. That just reflects the conflict of interest source of a gift requirement that looks back 12 months from a decision when there's a gift involved. But it could also be something that is currently pending or foreseeably occurring in the future. So that is something for your consideration. And then I'll pause here until I go on to the third category.
All right. Thank you. Commissioner Baker, questions for Ms. Harrison?
Thank you. I really appreciated these recommendations. And even though some of this information may be gathered through other means, I think having it as part of the behested payment reporting is a good goal. It couples it with the data that's in the reporting itself in one area, makes it more transparent, even if it can be duplicative. One or two areas I wonder if you could look into as well is when there's a great brief description of the relationship an official may have with the nonprofit. You mentioned certainly if they're a director of the organization, if they are a family member, senior staff or campaign staff are, but there's also, if there's any other control they exert. Maybe they aren't a majority vote, but maybe they were the founder of that nonprofit and they don't technically vote on it anymore. I would look at any other ways of connection that we might not be thinking of that could have that impression. And a second one is on the description of whether or not the nonprofit may have some permit or license or interest contract potentially before that official or body. You know, those nonprofits may also take positions on, and the donors may take positions on legislation, even if they don't necessarily get a direct benefit in the form of a contract or a payment. And I think that's something I would want to have more of a conversation about what other matters pending before that body the donor may have, because it's not just limited to a contract or a permit, like $1 that comes into their pocket in the 12 months. It could be taking a position on major legislation, for example. And then the final one is I like the 12 months. For a moment, I thought, should it be 24? Because, we're looking at, I tend to come from the legislature point of view, but some bills are moved over to the next year, and influence peddling as it is over the course of a legislative term and not just one time. I went back to preferring 12 months, but I'd welcome a discussion about that time frame. If you want to make it, 24 months is a long time period, but so often bills get bumped over. They become 2-year bills, and there's influence brought to bear within a legislative cycle. So those are the questions/comments I had on this, but I appreciated the focus on more information in the behest report itself. Thank you.
So, Ms. Harrison, I had a question for you on number one, the type of charitable organization. When it comes to behested payments, public officials, where do they receive that type of information in this context? Wouldn't they have to rely on the charity to provide that to them?
Yes, they would. And this is in the context that the elected official has some sort of relationship, cooperation, control, consent, that there's been some relationship between the elected official and the nonprofit in making this a behested payment or a payment made at their behest. So yes, they would receive that from the nonprofit.
Okay. So I think, I don't disagree, this might be useful information for some members of the public. I guess I'd like to know more really what the cost-benefit analysis here is, because, you know, if public officials are getting this from nonprofits, as you recognize in your next item, number 3, when we're talking about good faith estimates, part of the reason we're even talking about allowing folks to estimate is because of the problems that we're seeing with public officials in a timely fashion receiving information from the nonprofits and other folks that they're, you know, helping behest payments to. And so it just strikes me that the first item on your bullet list is just another thing that a public official may not know, and they may be waiting to get from the nonprofit. Or I suppose the other thing is you're putting an additional burden on the public official to go look it up if they don't get it in a timely way. So I think in this area, it just reminds me that part of the complication here is the statutes as currently drafted don't reach the folks who are receiving the behested payments and requiring them legally to actually provide that information to public officials. And I think statutorily, in my mind, that is an area that I would think the legislature might want to take a look at. I think that would actually facilitate more timely reporting, more accurate reporting, if there was actually an obligation to provide the information that public officials are expected to report. So agree, there might be value to it. I just flagged that one as, you know, how difficult is that going to be, practically speaking, when people are asked to comply with that. When it comes to the other 2 items, the known relationship, I mean, to me, it really is important that we limit it to known relationships. I don't think we can expect people to guess at things they may not know, particularly in the context where I think most public officials, they're behesting payments as kind of almost a public service. They're trying to get people to support nonprofits, and I think that's something that we want to encourage and not discourage. And the last one is on your final point. I agree that if somebody if there is a matter that is currently pending, and by the way, I would include something that's been a bill that may be in the second year of 2 years of consideration, that's still a pending item in my mind. I mean, I know that's legalese, but I mean, I think I'd still consider that to be a pending item. So I don't know that you need to have a look back period any longer than 12 months personally. I think it's most important that you know what's currently pending. I will say I have real concerns, though, at least how you have described the concept of the forward-looking. Your phrase is, or foreseeably occurring in the foreseeable future. That's a lot of foreseeing for somebody to do, and what's the standard? And again, they are already reporting these behested payments. I mean, often, you know, what gets lost is we hear about behested payments, amounts, who they're going to. The only reason we know that is because they're actually being reported. They're actually complying with the law and reporting this and disclosing it publicly. When you impose this type of requirement where you're asking somebody to foresee what could be foreseeable in the future, I think to my mind, I think it may make it a little unwieldy. So I would focus more personally on the currently pending and maybe a reasonable look back period. And if you're going to do a forward-looking period, it's got to be a lot tighter than foreseeably occurring in the foreseeable future. I mean, it would have to be actual knowledge that something is imminent or something of that nature. Otherwise, I have concerns with that language.
I'll take the blame on the second foreseeable in there. That was actually a typo.
All right, fair enough. So, but you get my point. I think the standard needs to be really tight if you're asking people to identify something that they don't actually know.
I think here we were looking more for direction as to what the commission is concerned about. If it's more like a gift rule where we're looking back 12 months prior to the decision, or if we're going to be looking forward and then explore that area. So looking for guidance on that.
Yeah, well, I mean, and see, in this, Ms. Harrison, you get right to it again, because, you know, you use the phrase, well, it's like the gift rule. See, we already have a gift rule that already can be applied if there's something untoward going on. So just conceptually here, are we doing something to assist in enforcement of the gift rule in the context of behest, or are we talking about something that's important for purposes of understanding a behested payment? Like, how do you conceptualize this?
I think that there's been raised the concern of just as Commissioner Baker was talking about, is there a purpose of influence, and how do you capture that and disclose things that may be of concern to the public?
Let me ask you, I appreciate that. So under the statute, how far can we go? Like, where are the outer limits of the additional information that we can request? And what's the authority for asking about influence type information in the context of behest?
I think that the authority would be based on the definition of a behested payment, that its principal purpose is for charitable, legislative, or governmental purposes, and that the disclosure would be basically laying out these purposes, and then sort of following up with any other transparency that would be necessary to show that this is a true behested payment, and not something in the guise of a behested payment when there's other factors going on.
So let me ask you this. Suppose that a public official, we have this requirement that a public official has to disclose on a behested payment report whether the donor has a matter that's currently pending, and they check the box. And so this donor does have a matter currently pending. What is the legal consequence to that today? Is that prohibited?
No, I think that it puts it in the category of a conflict of interest analysis.
Okay. And we have conflict of interest rules that already exist that we would apply in those circumstances?
Correct.
All right. Commissioner Baker, do you have any additional questions for Ms. Harrison?
I don't, although I do think that last one, the first one that you're mentioning, Mr. Chair, about identifying what type of charitable organization, tax ID number, I actually think that might become the easiest thing, because the organization's going to know. It's if they're responding to the calls at all or the inquiries. That's the last one about what's a brief description of what's currently pending is significantly the greatest quagmire. And how a legislator, I keep talking in terms of legislator, probably because that's where I came from, but we're also talking about other officials in the state, how they are going to describe that and make sure they capture everything, and what happens if they miss something. That I think is going to be much more of a challenge than the first one. Although I respect that you pointed out that's sometimes a difficult one. And I would like to have us have this conversation. I know we're giving some direction back to the staff here about looking into it further. I just know that's going to be the one that's going to be the trickiest, and potentially set landmines that we want to be very careful about setting. I think we should have that conversation. I just think that's the bigger issue. And appreciate your point about foreseeing into the future. Who has that crystal ball? I do not know.
Me either. I do think, I just want to say, Ms. Harrison, I do think conceptually the last bullet point, where we're talking about business essentially before the public official, I did appreciate how I think when you wrote this, you were intending to be pretty targeted. You're talking about a contract, a license, permit, other entitlement. So if I'm reading this correctly, general legislation that would affect everyone wouldn't get picked up in this. It would have to be something that's pretty specific.
That's
that
correct.
The donor has. Okay. I do think that's important. All right. Any other questions or comments for Ms. Harrison on point 2 before we move on to number 3?
No, thank you. I think we gave a lot of good commentary on this one, and I'll look forward to the future conversations.
Absolutely. All right, Ms. Harrison, back to you on number 3.
So going to the point about the difficulty in obtaining information, the information that an elected official has to report under Section 84224 comes from the organization that's received the payment, unless the elected official somehow has other knowledge. And they must disclose the payment amounts within 30 days of the threshold being reached, the $5,000 threshold. It's been raised in the past meetings that this can sometimes be a problem. And I think it's been discussed in the past that the most important thing on behested payments is that it get reported. So in order to try to facilitate it, there was a discussion that perhaps good faith estimates of payment amounts should be allowed. And especially this came about in the context of the pandemic and state of emergency being declared and nonprofits scrambling to adjust to those circumstances and filings still being required to be made. With that in mind, staff took a look at what that could look like to allow good faith estimates. There are some concerns that we flagged. We wouldn't want this to become the rule, that it's just easier to file a good faith estimate and never get back with the corrected amounts, and just what would that look like and how that would occur. So we've offered some options. One is perhaps making the official explain briefly the circumstances for doing a good faith estimate in the report, that the official would need to make a written request to the recipient payee organization, and perhaps even reach out to the payor if they're aware of who that is, and basically practice reasonable efforts to obtain the required payment amount information from the single source prior to the deadline. And then make a requirement that an amended report with the correct information needs to be filed within a particular time frame. And all of these raise difficulties and issues, and makes one wonder if a good faith estimate serves a purpose or if it just complicates things. So the commission may want to consider limiting it to a situation like we've had this past year, where there's been a declared state of emergency or some other type of circumstances that would warrant this.
Let me ask you this, Ms. Harrison. I appreciate staff's concerns on this. If you have a public official today who isn't getting timely information from a nonprofit about the amounts that they're receiving pursuant to a behest, aren't there options today essentially to file something that is their best estimate, or they just don't file at all, in which case the public is completely deprived of any information?
I'm actually not aware of how that would be handled.
All right. Well, Commissioner Baker, I know you have some experience in this, and we've heard anecdotally it can be difficult sometimes to get the information you need to file those reports. So what's your experience been?
Yeah, so my experience is, first of all, when I was a legislator, I did no behest payments because I just wanted to avoid all of the complexity and to make sure that I didn't step on a landmine, but also because to avoid any of the appearance of impropriety and get into that debate. It doesn't mean legislators can't do things that can highlight and make the more generalized requests for nonprofits. But I have to confess, I did not file behest payment forms because I wouldn't do it. And I actually resigned from any nonprofit that I was involved in. So that said, I've certainly had many colleagues who, and I see the complexity they've had. More recently, I've been on nonprofits where a legislator has wanted to MC the event that we had, which gives us the benefit of people want to come to our nonprofit event, but we had to work out with the legislator in advance. We have to get back to them within a time frame to help them comply with the behest payments. And it can be a total nightmare for the legislator. It's also similar sometimes to gift rules, where if you're someone who has a no gift policy and you're trying to make sure that you provide consideration for anything that could have been considered a gift so that it isn't, really having to track those down within the time frame is difficult. I will say this, most legislators have staff and a reporting agency and staff person who's there, and it's their job to help assist with that. And they can make their best efforts. I mean, if I were talking to someone in the clerk's office or council and say, give it your best estimate. Problem with that is the following. It can be totally wrong. I mean, trying to track down contributions from people who've pledged to actually give you something can take months for those checks to actually come through. What we don't want is to stop with the best, hey, give a best estimate and have it be a real low ball and the people walk away and not try to have transparency because it's difficult. So that's been my experience. It is something that many legislators still participate in because they know the good that can come from, there's good and noble things that come from supporting nonprofits and asking for that. But the behest payment itself is difficult within that time frame. I tend to be unsympathetic because you can see it coming. You can alert the nonprofit that, hey, I'm going to need this information if you want me to be involved. And you can make, you should still do a filing for it. So that's to give you the perspective of someone who didn't do behest payments at all.
What's your sense on, do you think that if we did a reg that permitted estimated reports with the types of guardrails that Ms. Harrison was describing, where you can file an estimated value, but within 10 days of getting the actual amount, you need to amend your report, and these are the safe harbor ways that you show reasonable efforts, you know, having written a letter, make a phone call, whatever the case may be. I mean, what's your reaction to that, Commissioner Baker?
It's what will trigger the reapproaching to the nonprofit to see if anything changed, right? So the nonprofit is going to be really busy and they're likely going to forget, or they just, you know, they're going to have their own staffing and priorities. They're just trying to get in the contributions and do the work. This is all when it's above board, by the way. And then on the official side, they're also busy. Their staff is, and the official who has to sign it has filed their report. And how are they to know how far off the information is and if they need to go back? So we need to give some more parameters for, you know, if you make a good faith estimate, you have to go back within a certain time frame and affirmatively seek that information. It can't be left to uncertainty about who's going to get it. I think that would be my biggest concern is, you know, are we waiting for the nonprofit to remember to go back to the official, or for the official to remember to go back to the nonprofit and get the final amount? I think it's a little bit easier to put it on the official. Frankly, I'm sure if I were sitting back in that chair, I'd think, thanks a lot for putting something more on my staff. But I don't think we can leave it too loosey-goosey where no, it's not really specifically assigned that you need to go back and get that information because it'll never happen. And perhaps through no nefarious means, it's just people move on to what's their next priorities that they have to be dealing with.
All right, I appreciate that. So, Ms. Harrison, I think I'm hearing that we are interested in this idea, but there need to be some tight guardrails along the lines of what Commissioner Baker was just describing.
And I would, you know, throw in there limitations on when good faith efforts are allowed, because that can make an awfully big expansion, which is, you know what, if you guys don't have time, you can't get it to us, we'll just make an estimate and move on. And which the idea is we'd like timely, as contemporaneous as possible, and detailed reporting for the sake of transparency. So I think we're asking you to do something quite magical here with coming up with the perfect, perhaps, but that's an additional thing. Is I would like to see some limitation on when best guess is going to be allowed.
All right. Ms. Harrison, are you able to decipher what we just asked you to do?
Yes, I think that those parameters are important. I think it's hard to know if giving an official, say, an extra 10 days to file an amended report, you know, 10 days was just a time frame that was proposed. How giving them an extra X number of days, whether it's 10 or 20, how that might be helpful. or how it might just result in stringing out the whole process. That's why I'm interested in your comments about limiting it to particular circumstances, such as I think a state of emergency is sort of one end of the circumstances that it makes sense to allow it in those extreme circumstances, I guess is what I'm saying. And I'm curious if you would like us to bring back proposals of several circumstances where it might be appropriate, or if you're more interested in taking that more hard limitation line.
Well, if you're asking me, I'm not interested in confining the estimate to just declared states of emergency, because here's an example. Public official makes the request of the behested payment. Behested payment is made. Public official directs their staff to reach out to the nonprofit to get the information necessary to file the report, which is due within 30 days. So there's a time ticking, right? And their staff, and they can document and they can show to us they have done this. They've made phone calls. They've sent letters. They have not gotten a response. And so I think under those circumstances, in my mind, the public is left with a situation where either the public official doesn't have the information and can't compel it, and they're not going to disclose it within 30 days. Or I suppose we could extend the deadline for some period of time, although if the nonprofit continues not to be responsive, I think you still end up where there's zero disclosure of the value. Or under those circumstances, you allow an estimate. So something, a good faith estimate, not just a random number, but a good faith estimate, so that the public has some information and the public official isn't stuck in this, I think, impossible choice of either I don't file something and then, the FPPC is going to fine me for that when I find out about it, or, it's an untenable position. So I'm trying to think of a way to assist that, because Ms. Harrison, I think one of the things you told me recently was that not filing the reports. That's one of the biggest issues that staff has identified. So this proposal to me goes right to the heart of how can we make it easier to get that information out in a timely fashion. Anyway, that's kind of how I see this idea. Commissioner Baker.
I'm sorry. I was just going to comment that in some of these circumstances, because the focus is on the payment coming from a single source, you might have multiple nonprofits involved. So you might be an elected official and know that you had a single source making a payment to, let's say, 3 nonprofits, and you've heard back from 2 of them, but the other one's dragging their heels and you don't have that set information from that one. And I can see that as an instance where we would want to encourage the estimate and get those amounts filed, where you've got 2 that are sure and one you think you've got the right idea.
That's a good.
Thank you. I appreciate that. I think one way to potentially work on this is if it's that situation where the nonprofit or 2 of the 3 of them are not responding at all, what we don't want is the official files nothing. So that's part of an education campaign on our part as well, which is you still have to file it. And number 2, if we want to make, and I know there's been some proposals about what's on the form to make it more clear, if it is checking a box that says this has to be a best estimates, all good faith efforts have been made and we have not received the information from the recipients yet. And if you click on that box, maybe that triggers a time when you're going to have to file again in another 30 days, just to show that you're still trying. I'm throwing that out there, having not fully thought it through what the pros and cons are, but it allows the official to get the thing filed, make a best estimate, and to indicate this is a best estimate because we have made all efforts to get information from XYZ, and you have to just, identify who they are. We've been unable to obtain it. We're making our best guess. I mean, that's kind of throwing the nonprofit under the bus a little bit, but, and also in the education campaign, if I were sitting as elected official and I'm thinking of making a request on behalf of a nonprofit to send money their way, one of the requirements is you have to get back to me in 30 days. So do whatever it is you need to do to get this information and provide me upfront. What are you hoping to raise from this request? And that might be part of our, again, education campaign, and we can decide what to do on fact sheets and otherwise. that provides that information and that encouragement. Just some ideas.
Good point. Ms. Harrison, has that been helpful? Do you have a better sense of what we're looking for on this item?
Yes, very helpful.
All right, great. All right, last but not least, number 4.
The fourth item is third-party fundraising solicitations. This is an area where we got feedback that perhaps it could be clearer, and that there are particular situations that that could be addressed, perhaps in regulation, perhaps in a fact sheet. And staff proposed a lengthy version of a fact sheet that tried to cover a lot of the scenarios that we felt might be cause for confusion, such as when there's multiple officials making a behest at the same event, that each one of them has the behested payment reporting requirement kicking in. So we thought that an option the commission members might want to consider is either amending or repealing and replacing the language in Regulation 18215.3, and cleaning up the solicitation language to be a little bit more straightforward as to how right now it's termed in a safe harbor language. So it's when you are not violating it, which is how a safe harbor works. And we thought it might be simpler to address it directly as far as when you're considered to be making a behest if you've been featured in a solicitation, and perhaps also giving some guidelines for a reasonable time and considering when a payment is responsive to a solicitation. Addressing the issue of a guest speaker or an honoree where there are no other facts involved that show coordination, cooperation, consent. That comes from an advice letter, the Wiener advice letter in 2014. And also perhaps address situations where there's donations. We heard a lot of frustration about this in our very first law and policy meeting back in May, where there's donations that perhaps are able to be demonstrated that they're not responsive to the elected official solicitation. And the example that we thought might work for your consideration is where there's a scheduled donation and there's a documented history of past donations and no facts indicate otherwise that the donation was made at the behest of the official. These are items that could be clarified, as I said, either in an amended 18215.3 or in a repeal and replace with new language.
Great, thank you, Ms. Harrison. Question for you, bullet point number 1. Who is responsible for making the determination whether a payment that is received by the nonprofit was responsive to a solicitation? Is that the public official that is supposed to make that determination, or is that something that the nonprofit is expected to do and then communicate that to the public official?
I don't think that's addressed directly in statutory language. So I think that process would likely be a collaborative process between the elected official and the nonprofit. The way I see it happening is that a nonprofit has a list of donations that were a result of an event, and that the elected official then processes that information.
Okay, so our regulations don't provide any guidance on who and how to determine whether something is responsive?
I think if the elected official is involved in a solicitation, it's assumed that every donation that comes in is responsive to that. I think it becomes difficult when you're talking about a mailed invitation. That's one thing. When you're talking about a post on Facebook that then might get shared and reposted, that's another thing. When it's specific to an event, it's a little bit more clear. So it can get complicated. It can also be a very simple situation.
Yeah, no, I'm with you on, if you send a written solicitation with a little check the amount you want to donate and send a check back, to me, that's really easy, right? But if you attend an event and a public official speaks and, you make a donation, 3 months later, is there a temporal element to it? Does it have, if the donation isn't made at the event where the public official is speaking, I'm just trying to get a better sense, particularly since if we're going to try and regulate in this area, I want to have a better understanding on the front end of how the logistical piece of it actually works and who's keeping the information, how they're keeping it, and when are they sending it.
Sure.
So
And I think the idea was to keep it temporal, like the 30 days is referencing the 30 days for reporting, but recognizing that you don't report every behested payment. You only report when it aggregates to that $5,000 amount. So you might be looking at more than one solicitation. So as I said, it can be simple. It'd be nice if you sent an invitation and you said send money and they sent a $5,000 check, then you've got a pretty easy, clear-cut situation. But this was to try to give some guidelines, I think, to the elected officials of what they should be looking at as well. I think your 3-month example is a good example. It seems a bit out there.
Right. Well, and also, I mean, again, mindful of the fact that we do not directly regulate or impose any legal record-keeping obligations on the nonprofits that are receiving these payments. They may not reconcile in the way that we think would be ideal in our minds in a 30-day period. So again, it's just kind of, for me, I'd be curious if we had some nonprofits we might be able to talk to get a better understanding of the processes they use and the timelines that may be at play there. So,
that would be excellent. And we've sought feedback from nonprofits. Unfortunately, given the pandemic, nonprofits were pretty clear in responding back that they didn't have time or bandwidth to handle these issues at that time. Maybe in the next few months it'll improve.
Right. No, I appreciate that. Second question for you on bullet point number 2. Appreciate what staff is proposing here. My question is what is the status of it as behest or not behest if a public official is an honorary member of the charitable organization? They don't control it. They are like, think of an ex officio. They're there. And their name appears along with all the other board members' names on the solicitation. Behest or no behest?
So you're saying that they're not board members of the organization?
They're honorary board members.
Honorary board members. So I think normally in that situation, you'd have to look at the full totality of the facts, which is what makes these things complicated. But I think that generally, if their name is being featured in the solicitation, if it's being singled out as an honorary board member, then that would qualify as a behest. Unless there were facts to show that for some reason it didn't. But you're always looking for that fundamental made at the behest of definition. Was it made with the cooperation, consent, express prior consent? Those types of factors are always at play. And the featuring in some ways is just sort of a convenient way of understanding that.
Right. So I guess what I'm trying to understand is under proposal number 2, it looks like what staff is recommending is just if the elected official is identified as the guest speaker on a solicitation, so they are singularly being highlighted as the guest speaker, that would not be a behest. And so what I'm trying to understand is, so you're proposing that would not be considered to be a behest, but if you just had essentially an honorary title as part of the organization and they send out a solicitation and all the board members are listed and you are included, I think you just said that could be a behest.
I think so. And what you're looking at is usually that's in the context of you'll have an honorary fundraising committee for this particular event, and the elected officials might be listed as a member of that honorary committee. And it's in that context, it's pretty clear that they're consenting to cooperate and raise funds. And that's why they're being featured in the solicitation. When somebody agrees to be a guest speaker for an event, they're not necessarily endorsing the fundraising component. So we were trying to find a way to recognize that, and considering whether or not the analysis in the Wiener letter would be appropriate to perhaps put in regulation to give people more guidance.
All right.
I think some of this is seen in the enforcement context, but I think coming from an advice background, I see it in the guidance of giving parameters so that nonprofits and elected officials have a better sense of what's being asked of them.
Okay, well, that's helpful perspective. Commissioner Baker, questions, comments?
Thank you. First of all good questions, some of which I had as well. I'd like to go back to the time period one, bullet point number 1. And this is not so much a question, it's feedback. I mean, I'm imagining a situation where nonprofits have a 6-month campaign to raise funds for something. A nonprofit in our area was just doing a 6-month campaign to get people to give a brick, sponsor a brick in front of their building that has their name on it. And the elected official, may have gotten involved in some way with those requests, along with many other luminaries in the community. And that's when does the reporting period trigger? Is it the end of the 6 months when you feel like you've raised the nonprofit says they're raising all the money? It's so when there's not a specific event in time, but there's a long period of time potentially, it's going to be important to flesh that out. When's the starting and stopping period, so that the people who want to comply, the officials who are trying very much to comply, know when does my obligation trigger? And I think as much clarity as possible as we can provide on that is important. For the second bullet point, we're mentioning guest speakers and honorees. I mentioned in a prior conversation here, when a member of the legislature emceed an event for a nonprofit. They're not an honoree, they're kind of a guest speaker, but they may or may not say, please give money. So we're starting to really get specific here. The number one thing we need to do is just be very specific in the guidance so that people of good faith can comply and the transparency that we're looking for is available. And that needs to include potentially a conversation about if they MC it, but they do or they don't ask, that you give money to the organization. Are they MCing an event that you don't have to pay to come to, but contributions then are given to the organization as a result of the event happening? We've got to provide that kind of guidance. Difficult to do, but I'm just thinking of all kinds of circumstances where that may come up. Now you can see why I didn't get involved in advance payments at all. I just didn't want to get into the possibility of problems. And then the final one I think is how the official is going, and this goes to the third bullet point, if they're going to know if a contribution that comes out of something, it turns out to be every month now for the next 2 years, I'm going to give a regular contribution. I'm trying to think of those, the NPR's radio announcements asking to give money. Let's say an elected official said, please give to NPR. And people end up giving and they give a contribution, $10 a month out of their paycheck. How is an elected official going to know when it falls into the category, not just of a result of their ask, but a more serial contribution that comes out of it? And where does the official's obligation stop? That's where I'm raising questions on that third bullet point.
And just a brief comment in response. I think some of these were ideas that were presented to staff and raised in the various law and policy committee meetings that we've had. And not all of them are going to be completely workable ideas. There is always that tension between drawing a red line and allowing things to be addressed in statute, and we provide advice, formal and informal advice. So that was an issue that was raised, that some people really objected to the fact that they got swept up in the behested payment reporting. And it was merely for consideration. Would this possibly be something the commission would want to consider to try to be more selective in what's swept into that net? Mm-hmm. But I think you raised good points on its workability.
Yeah. And then also if there's a presumption, and I think you mentioned one, I sort of was trained on that there is a presumption. If your name as an official goes on something, that within the content of that letter, even if you're listed with all the other board members and you're, a board member or an immediate past chair, but you're on that letterhead, or whatever it is, there's a presumption that, you know, that's a behest payment. And I'm sure there's been many, many advice letters and rules on this. I think we want to find out if there's any other presumptions that we're going to make here. I don't know that there are. That, you know, a presumption that after 30 days, all the contributions that would have come in are going to come in. Well, you don't want them to try to skirt the rules and say, just tell me what you had after 30 days when 3/4 of the contributions came in on the 40th day. We want to see what presumptions we're going to put into the regulations. These complex, and I appreciate the work that the policy committee has done in the prior year on this issue and that the staff has been doing on it. I'm looking forward to what's going to come back to us for sure.
Yeah, I think on this point, on the third-party fundraising solicitations, I do think that we have heard in the past frustrations with the complexity of these types of rules as they're currently drafted and applied. So Ms. Harrison, I think you are correct in identifying this as an area for potential improvement. And to Commissioner Baker's point, I think even though it's hard sometimes, I think trying to draw as many clear red lines as possible for folks would be really helpful. And consistency too. You know, I was picking on the bullet point number 2, and my point, I thought it was very clever, Ms. Harrison, because I said just an honorary board member along with everyone else. And when you responded, you referred to, well, an honorary board member of a fundraising committee, which is different in my mind. That's another permutation. But my question was more generic, where their name is just listed with maybe 20 other people on a solicitation. There's no call out to them. And as you said, our analysis there is going to be complicated, essentially. We're going to look at a bunch of different factors. But then in this proposed example, we're saying that the mere identification of an elected official as a guest speaker or honoree, and those words are significant. You're now taking these 2 categories. If I say I'm a guest speaker, now we're going to treat it as presumptively not a behest. And to me, and I admit I could be missing something, but that's not intuitive to me. Like, there should be some consistency across the board there, that, you know, elected officials, a name on the solicitation, wherever it may appear, alone isn't enough. There has to be an actual call out for solicitations, or take it the other way. Their name is presumptively a call out for behest. But I just think we need to be consistent across the different permutations here, you know, and not get too caught up in, you know, well, if you're a guest speaker, we're going to treat you differently than if you're just an honorary member along with everybody else at the top. I think that is it. To me, it's just kind of a trap for the unwary. I appreciate what you're trying to do. I do. But I think in practice and in reality, I think it becomes more of a trap than it may serve the purpose that we're thinking of here. That's my sense on that. Commissioner Baker?
You know, as you're mentioning that, I'm mindful of how we sometimes have exceptions in the gift rules where it's something's not a gift if, let's say, a official goes to an event and gets dinner at the event, but they spoke at the event. And so here there's an analogy in the gift context that we may want to look at, or at least be mindful of. Where are we going to be consistent? And sometimes speaking at an event is a pretty minor role, and what the gift context is. So as you're saying that, I just started thinking of other areas that we are involved in and that are within our jurisdiction where we talk about that. We might want to draw on that.
Yeah, I agree. So, Ms. Harrison, I think in summary, we're looking to you to clarify something that is incredibly complicated so that everybody can easily understand it. Do you have any questions for us on item 4 or any of the other items that we've talked about today, or do you think you have enough guidance on those items?
I think that you've given us some good feedback, and I look forward to going over this and seeing what seems workable to address. And I guess my only question is that if something seems that just from today that the committee has sort of acknowledged that maybe that's not workable or not something worth pursuing, I'm going to assume that you don't want to see any future language on that. Is that correct?
Yes, I think that's, at least for now, to my mind, you've, very helpfully numbered the different items in your report. I think item 1 is problematic and maybe, and I'm just not even sure it's necessary. I take number 1, and a lot of your comments on number 1 they're well received. I just think perhaps another approach to the issues you identify in number 1 is really focusing on training, outreach, manuals to remind folks that you have really, under the Act, you have multiple obligations simultaneously bearing down on you. So yes, you have to report your behested payment report when you behest those. But if you end up attending an event that happens to be paid for by a behested payment, you also have to be cognizant of the gift rules. It's not enough that you just filed your behested payment report. That type of a reminder to public officials through our training and outreach, I think gets at a lot of what I heard you talking about under number 1. I think substantively, items 2, 3, and 4 are things that, based on the feedback we gave you today, I think you could continue your work with other staff members to develop some more concrete proposals to come back to us on. But Commissioner Baker, that's my takeaway.
I agree. I completely agree. In fact, you said that well, very well, that about item 1 versus the other items as well. And I think for now, this hopefully is helping prioritizing, because if we've given, you asked if we gave feedback that something might not be workable, does that mean not to come back? For now, I agree with the chair, no, because we've got some specific areas that we already know we need to be working on. I will say, however, that if what's made them unworkable is we just haven't come up with the right solution, but we can always hope to do that. I do want to point out, if I could, before this meeting, I had really tried to distill from the prior law and policy committees and some of the media reporting, what are the areas that are really concerning and what we as a commission have to deal with. We've talked about today, and I think you have feedback on when a legislator controls a nonprofit and they have some kind of connection and it's something that they influence and drive, where a legislator is enriched in some way by the nonprofit. I think we've talked about that today, either through money that's coming to them, and I hope we're going to be looking to other benefits in kind and being able to piggyback on the nonprofit's resources. I think that's important. When the nonprofit has business before, and the person giving the money has business before the legislature, I think that's really important. But there's just a couple that I want to make sure we're still thinking of working in here. When the nonprofit that we're talking about is a caucus nonprofit, where it's the legislators control it and not just one particular legislator. I think that is part of the world that we need to be looking at as well. There's many caucuses and within California's legislature and otherwise, they not only get government money, but they are the recipients of behest payments. And I just wanted to emphasize that when we talk about legislator controlling, it includes those as well. Would you agree, Mr. Chair, that we're not just limiting this to the ones that are controlled by one official?
Well, I think behested payments, to my mind, it crosses a lot of different areas. So it's not something that I have heard staff identify as a particular area of focus for either enforcement or that we get a lot of questions on it. But if the application of our rules in that context makes sense, then I think we ought to hear information about it. It's just not something that over the last few months has been identified as a problem area.
Okay. I mean, I guess I'm thinking of a scenario where, that's another area where influence can be brought to bear, except instead of just one legislator, it's multiple ones that control it. And so I get what you're saying. For my part, I think it's good to be looking at that and including it in that area that we're already looking at. But then the other scenario that I don't know if we've covered is where the nonprofit is getting a benefit that comes later. I know we talked about that 12-month, how much are we going to be able to look into the future? I mean, one of the things that has gotten attention, for right or wrong, is after many nonprofits, there's many behest payments that came through, maybe some no bid contracts then happened to land in those entities. And I know there was reporting on it. We haven't really talked about it, but within what we're allowed to do, I don't know that that's what we can do about that. Where there's that appearance that after behest payments were made, the people who made them then got a government, happened to get a government benefit out of it. So when the nonprofit is getting something else out of it beyond contributions, or the entity that gave the money. I'm just throwing that out there because I know that it's gotten a lot of attention. I'm not looking to pick on a political issue. I don't know if what we've talked about today covers that scenario, or if that maybe we return to it another time.
Yeah, I mean, to me, that sounds, it's almost and I use this term in the lay sense, not in the technical sense, but almost like a pay-to-play type thing. And the act, I don't think the act is where we would look for the remedy under those circumstances. I think that the question is has there been some manipulation of the public contracting rules or something of that variety? I actually don't know that it legally changes the nature of a behest into something else.
Mm-hmm.
But,
and maybe
what
that goes to is all the more reason why we need to have reporting, so that folks want to try to track down these issues and raise it for public debate. It's available because it was reported.
Right.
You're right. We may not be able to do anything. It may not be within our jurisdiction, but it goes to how important reporting is. And finally is the idea that as we're looking at, Ms. Harrison, we're looking at these rules. I remember from one of the prior meetings, the issue was raised, how much you have the legislator going back to the person that they request to give the money to ask, hey, how much did you give money? How much did you, what were the results of my request? We don't want to begin to distort the system by kind of making it look like we're bringing influence to bear. We're actually asking the official to push people to give money by having them track down the dollars. And where I'm going with this is, as you start to come back to us with proposals, just be sensitive to that. And I think we should be as well. Could we inadvertently, by putting a requirement on officials to go back and track things down, where we're going to tell them to go track it, we don't want to be increasing what might look like arm twisting to give money. I just think we need to be really careful of that. So that's my only other feedback.
Just to be sure I understand, Commissioner Baker, what you're talking about there is magnifying perhaps the influence that a payment might have over an official, because an official becomes hyper aware of the situation.
If we are going to try to give them bright lines about getting the dollar amounts and making the best good faith effort you can. And if we say, and in doing that, you might go back to the people you asked to give the money and say, how much did you give to the nonprofit that's not responding to me? That might lend it to look like we're starting to tell the official not to shake people down, but to try to pressure even more contributions because we're telling them you have to give us information, you have to give us good faith estimates. I want us to avoid potentially making the system look worse. Does that make sense?
Yes, I think you're saying that the focus should be on the official and the recipient organization rather than the payor.
Yeah, and try to avoid pushing them to get those good faith estimates and otherwise from actual donors. It is unseemly potentially.
I see. Now I see what you're saying.
It took me a minute to get that out. Yeah.
No. It took me a second. But I think you're absolutely right. I think what you're saying is the first and primary point of contact for the public official who wants to satisfy their legal obligation is the nonprofit.
Yeah.
It's not the donors to the nonprofit who are contributing at the official's behest.
Yeah, and if we're going to be coming back with some potential additional regulations saying by this time you need to give this amount of information and good faith estimates have to come from these sources, let's not veer down the road where we're trying to have them go talk to particular donors to try to get even more influence over them. That's where I'm going with it.
Yep, that's a good point.
It's a cautionary tale.
Yes.
Point taken.
Took a while to make it.
All right. Ms. Harrison, any additional questions or guidance you'd like from Commissioner Baker and I as you set off to solve all these problems for us?
I think the only additional information would perhaps be a timeline.
So in my head, I was thinking it'd be nice to get something in next month. So July, maybe report back in July. Commissioner Baker, I don't know if you feel strongly it has to come back next month. I think next month we have the online media, the online disclosure regs at a minimum that would be coming back to us, unless I'm misremembering, Mr. Bainbridge.
Yeah, I think that's right. The pre-notice on this is set for July, so I would think having either if you want it before the pre-notice or after, we do it both ways. So you'll get a better project in July than you will in June, I can assure you that. So I would say we stick with the schedule and we can bring it back in July. It'll be a week before the commission meeting when it's heard for pre-notice.
All right. Commissioner Baker, what do you think?
There's a lot of complex, very meaty issues that we were asking the team to work on, and we'd like to have the best possible product, and I think July is reasonable.
Okay, great. And in the interim, at least from my mind, I think, I've had a number of questions. I think Commissioner Baker has too, just about the nonprofits and how they're experiencing some of these obligations and how they're experiencing the communication with public officials. So, Ms. Harrison, if you and your colleagues could take a crack at getting in touch with some of the nonprofits and getting a better sense of logistically how they're tracking this information, how they're keeping it, how they're communicating it. At least for my part, I'd like to have a little bit better understanding of that. And then more broadly too, I don't know if you could do an IP meeting between now and July, an interested persons type meeting where you invite folks from the regulated community to provide their input on this issue. I think that might be helpful. We haven't done one of those in a while. Just to kind of get everybody coming together and focused on this so we get all the perspectives folded into it.
Okay.
All right.
Thank you.
All right. Well, thank you.
Thank you.
You've done a lot of work here, Ms. Harrison. It's complicated, and I think you're doing a good job here. So we appreciate it.
Thank you.
All right. Moving on to our final items for next month's agenda. And I think we just heard one of the potential items, and that's the online media disclosures. So, and of course, we'll have our legislative update. Commissioner Baker, did you have any other items that you wanted presented next month at Law and Policy?
Yeah, I think that's going to be a pretty meaty subject for us to do. And with the additional legislation, the only thing I would add about the legislation is, and Ms. Nakano is very good at this, if there are, excuse me, triggering deadlines, there always are. There's the House of Origin deadline and those. If that might get added to either the memo or the report, that helps us understand, frankly, what's reasonable feedback that we can provide. If we're coming to you and saying, hey, let's put this in there before it comes out of a House of Origin or otherwise, it allows us to be reasonable in our expectations and to provide specific guidance. And I think by June, there's going to be not only House of Origin will have passed, but the budget by the 15th, at least, if I remember correctly, will have happened as well.
Right. And I can tell you, Ms. Nakano is shaking her head affirmatively. I think she is willing to add that to her report. So we'll look forward to that going forward. So,
thank you.
All right. So anything further before we adjourn, Commissioner Baker?
No, thank you. Thanks to the staff again for good, meaty subjects.
Yes, very good. All right, I will move that we adjourn then.
Second.
Commissioner Baker? Ms. Linker?
Commissioner Baker?
Aye.
Chair Matich?
Aye.
The motion passes.
Great. Thank you very much. I will see you next week, Commissioner Baker.
Sounds good. Be well, everyone. Take care.
All right, take care.